Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Sarah Boone is just the case that keeps on giving, and some of the stuff that it gives is just really kind of unbelievable. My wife and I have birthdays that are real close to one another. Hers is at the end of August, and mine is at the beginning of September. So a lot of times we'll take a few days and we'll take a trip, or we'll go down to our Florida house and laze on the beach. And that's pretty much what we did this weekend, this past weekend, I guess I should say, over Labor Day, because we had our birthdays. And that's always a fun time for the two of us. But because I put videos out and I run them sort of to provide for continual videos on the channel while I'm away doing other things, it is sometimes a real pain when events overtake them. And I originally had the Sarah Boone thing set to run several days before it did, but then something else eclipsed that, and as a result, it didn't run until yesterday. And as a result of that, it ran after she had acquired her new attorney. So we're going to talk a little bit about that today. For those of you who don't know anything about Sarah Boone, she was arrested back in 2020, after February of 2020, after detectives found her boyfriend, a guy by the name of George Torres Jr., dead after being zipped into a suitcase and left inside for hours. According to the cops, Boone told them that she and Torres had been drinking wine and playing hide and seek. I'm sure everybody understands that people who are in their 40s play hide and seek in suitcases all the time. I'm sure it's not weird or nearly unbelievable. But anyway, after doing so, she claimed that she went upstairs and passed out in her bed with George in the suitcase going, "Get me out of here!" Unfortunately, she didn't. And when she woke up hours later, she realized he might still be in the suitcase. She went, unzipped it, and found him unresponsive and not breathing, because he was dead. Boone called 911. Deputies arrived. They investigated. They arrested her. She has now been through 8 prior attorneys, all of them appointed. This one is operating pro bono, meaning he's supposedly not going to charge her anything for her defense. His name is James S. Owens, and he's from the Florida Panhandle. I initially thought he might be someone who was looking to make a name for himself by representing a notorious client, but it appears he's had a reasonably successful criminal practice in Pensacola, Escambia County. It's up in the Panhandle since about 2012 or so. In fact, here's a page from his website, and as you can see, he has a fairly extensive experience in terms of the criminal law. Now, why he signed up for Boone's abuse is anyone's guess. It could just be that he is bothered, the way many lawyers would be, about a client who has clearly a number of really significant mental issues going into trial undefended by competent counsel. And I have to assume that it's good faith that motivates him in this particular case. But I know y'all must be thinking that the reason Boone agreed with him for him to be her lawyer is that she wants to delay her date with judgment as long as she can. And that may very well be, but I'm sure Owens told her that he would need to get up to speed on her case and he'd ask for a continuance. That would pretty much be standard practice. He's got a lot of documents to go through, a very short time to go through them, and you have to understand he would have been negligent not to have requested a continuance in this case. So here's the motion he filed in order to get a continuance. It's not a lengthy motion, and I expect he wasn't counted on it being granted, but it does give him a ground for appeal if it's denied. Comes now the defendant by and through the undersigned attorney under Rule 3.190 of the Florida Rules of Criminal Procedure and requests that this court grant a continuance of the 3-week jury trial set to begin October 7th, and alleges, that it's set for trial, that he's just been retained as counsel, has met with the defendant only 4 times at the jail. During these meetings, the defendant disclosed potentially exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. The evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. Underside counsel has spoken with numerous potential expert witnesses. And those expert witnesses cover a range of possible defenses. Counsel is actively vetting several additional experts. It's professional opinion of counsel that the retention of one or more of these experts is crucial. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time not only for administering appropriate testing, but also the necessity to any expert testifying be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from the interviews. And so he's essentially saying, I need this additional time so that I can prep my experts. And then he goes down and says the defense certifies this motion is made in good faith. And then he files a memorandum of law here. It says the Constitution guarantees the right to counsel, and it's been recognized in a number of these cases that a denial of a motion for continuance may vitiate the effect of this fundamental right. And the case he cites there really is U.S. versus Verderame, which is a 1995 case out of the 11th Circuit. Of course, the 11th Circuit is where Florida is. The matter of continuance is traditionally within the sound discretion. The right of assistance to counsel not only reaches the trial stage, but extends to sentencing as well. So he makes this motion, and he says he would respectfully request this court consider a request to grant the defense motion to continue. Now, the case he cites in the memorandum there, U.S. versus Pellegrino Verderame, is readily distinguishable on its face from this case. Verderame was indicted and brought to trial 34 days later, and at the time the government had not provided all of its evidence and he had no time to rebut the government's case, and that included a $2.4 million civil forfeiture and the loss of his home. I doubt, as this was Boone's 9th attorney, that even Judge Jackson, who has a notoriously soft heart, would be much inclined to think that this was an abuse of discretion for the court to deny it. And deny it is what he did. Let's take a look.
Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case. Yeah. I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' bases for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you've met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and adjudged portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, excuse me, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Bargo v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JACS is not here and had the opportunity to review those. In Ramos versus State, 75 Southern 3rd 1277 at pinpoint 1281 by the Florida 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while his case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached a point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations at various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986. Were the duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in Turner v. State, 311 Southern 3rd, 185 at pinpoint 189, Florida 2nd DCA 2020, your motion for continuance is denied.
The judge provided a great explanation there. He went through the history. He explained things. I think pretty much he doesn't want to see this thing drag itself out any longer, so he denied the continuance. Again, I apologize for sort of being caught up in the delay because we had taken some time to go have a little fun. But I did want to get this out and get it out there because the other one sort of indicated she didn't have an attorney, and now clearly she does. At any rate, thank you very much for watching. If you have the opportunity today, do something kind for someone. Doing a kindness every now and then is one of those things that makes life worthwhile. After you do a kindness, or maybe even before, come on back tomorrow, catch me at the beach, and we'll do something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.